We'll now open the Reveal License Commission meeting. This is a continuance of our last meeting regarding the Corner Taste restaurant. What I'd like to do is have each council restate their positions on the issue at hand, and then if there's any additional information, we'll give you an opportunity to do that as well. And then from there, the commission will have a discussion over next steps. Please state your name and address for the record, please.
Mr. Chairman, Commissioner, James Cipolletta, 385 Broadway, Revere, on behalf of the petitioner and the applicant. So when we were here last week, we presented an application for a common victualers license, which was heard in part by the commission. There was an opposition from the previous owner, a prior tenant, and some others to the application. The commission then adjourned the meeting, continued it until today for the submission of additional documentation and further argument on the issues. Maybe for logistical and convenience purposes, the landlord to the property is here. And as you can see, he came up for 2 o'clock with one young child and has now acquired a second one. So I'm wondering if it makes sense to just have him tell you, and then what the arrangement is, and then I can follow up just so that we can get him and those 2 young children on the way.
Sure.
Mr. Previty?
Any objection, counsel? Please state your name and address for the record, please.
John J. Previty III.
Right, okay. And Mr. Previty, my understanding, our understanding is that you have a lease between Mr. Piccato and yourself.
Right.
Okay. And at what point did that go into place?
I think it's with 1st of October.
1st of October?
Yeah.
Okay. And for what period of time is that for?
Pardon me?
And for what period of time is that for?
3 years and 3-year option.
Okay. And was the lease, the prior lease, was that an expired lease?
That had expired, yes.
Okay. Did it run its term to the end?
Yeah, actually, it lapsed about a year, almost a year.
Almost a year?
Yeah.
Okay. And how did so at what point so in that interim period, what took place?
What took place?
Yeah. Well, what I'm trying to find out is that from the period of time that the current lease expired.
I started dealing with him, talked to him in the middle of September to find out what the story of the situation. Found the situation. I mean, I couldn't even get in. I have a lawyer. No, all right, okay, because I have a lawyer in Boston. Yeah.
Well, let me just make sure the timeline's correct. So the old lease ended 2015. Mr. Alba. So his lease ended October 2015. Is that accurate?
I think it was
September, October. Then you the lease canceled or whatever.
Oh, he was in there, yeah.
Okay, then he came. Diego came over with a new lease for Diego from.
Well, there was a lot of dealing going on, which I didn't know anything about.
So, but it started in October 2015.
Yes, right.
We started operating in October.
So
just to, just to let us know, he has the right, and it's
more easily dealt with, and that is whether or not Diego qualifies under the statute and the Revere regulations as the holder of a common victualer's license. So I thank council for copying me on some of the paperwork that had been submitted to the commission and had been in the file previously. And one of the things that I noticed is that there was a lease by the prior owner that began on, and it says commercial lease up at the top, and in section 3 it says the date of the lease commencement shall be February of 2002. So apparently there was a lease by the prior owner from February 2002 for 5 years. It lapsed, and then it was, apparently he picked up the option for the 5 years on September 1st, 2009 until September 2014. And that's handwritten to the side of paragraph number 4. So there's your 5-year lease on top of the initial one. At the expiration of that, Mr. Diego Preciado picked up his license as of the date stated on the new commercial lease, which is actually November 1 of 2015. The owner was here last week and said essentially that, I think his position was that he hired Diego and his family to come in and operate his business and essentially stole the business. Well, I looked at the operating agreement that was submitted with the submissions by the prior owner. And it's interesting to note that, and if you read them together, if you read the lease and the operating agreement together, the lease is for $1,200 a month from September 09 until September of 14. That's fine, it's a 5-year period at $1,200 a month. He then, under this so-called operating agreement, which I would suggest is not an operating agreement, it's a sublease, then sublets in paragraph 2 under the now wherefore clause to Diego for $4,250 a month. And that's from August of 15 through July 31st, 2017, a substantial period of time during which he actually doesn't have a lease with Mr. Previty. The original lease and the extension of the lease prohibits subleases in paragraph 13, assignment sublease. Lessee shall not assign a sublet in whole or in part any of the leased premises without the lessor's prior written consent. You call it an operating agreement, call it what you want. It's basically he's making $3,000 a month on Diego. Diego's not operating somebody else's business. That's not what was happening, although that was represented. What it was is it was an attempt to sublease the space under an operating agreement at a $3,000 a month profit. So without getting in, again, for the 5th time, I don't represent them in the Superior Court, and that will be hashed out with the judge. But to the second point, which is, I think, a simpler point, is whether or not the applicant for this common victualer's license is entitled to the license. And there is no disqualifying factor that would indicate that he's not an experienced operator, because he has been operating. that he doesn't operate a good business, because I don't think the commission has had any complaints about either the operation or the food. And he's, I assume, has passed the query check and all of the other conditions preceding to issuing the license. Is there a public need, not for Diego personally or his family to have the license, but is it in the public good for there to be a restaurant in the place where there's been a restaurant for 10+ years? And I would suggest yes. It's set up as a restaurant. It's at a corner of a business zone in Donnelly Square in Beachmont, and there is a public need, as the commission has found repeatedly, for a restaurant or the purveyor of foods and services at that address. So I would suggest, Mr. Chairman and Honorable Commissioner, that Diego has the rights to the property, and he is not disqualified from having a common victualer's license. We don't want to get into arguing the legal, Superior Court case here, so
Debate on the
I
merits
just
of the
got to,
case.
yeah.
My question is does he have a lease?
Mhm.
And is he applying for a new license? And both of those answers are yes.
Yes,
Okay.
thank you.
My question is, did your client agree to be the operator from August 2015 to July 2017 for that amount of money?
Yeah, he did, and he paid it. He paid it.
You paid all?
It apparently called for an upfront sum. It appears that there was an upfront amount of money in that operation. Paid in advance? He paid the 3 months. At 42.
Yeah, for almost 2 years, like this, 2-year agreement to operate from August 1st, 15 to July 1st, 2002 years, right?
Yes.
That was all paid in advance.
No, the rent was paid in advance, $4,250 for the period of time that he sublet the business until the time that he entered into the contract with Mr. Previty.
So, and I don't want to get into the case here, I'm just curious if he had this operating agreement with Mr. Alba. He just stopped, he just wanted to get out of that for, whatever reason that's kind of.
Yeah, he was basically the sub-lessee on a lease that didn't exist or that had expired. And that came about during his conversation with Mr. Previty, because Mr. Previty didn't have a lease with Diego. So he's saying, as Mr. Previty said, it was a little bit to his discomfiture at that point.
Mr. Diego had an agreement with Mr. Alba.
He did.
And he didn't fulfill that.
He did. For all of the 3 years, 3 months that he was there, he paid him a sublease fee of $4,250.
So this is 2017.
No, because he was subleasing, as Mr. Previty indicated, he was subleasing on a lease that didn't exist. And probably that's what they're fighting about in court, I don't know, but it would seem that that might be one of the issues as to whether he owes the balance of that money or not. That would be my assumption. Thank you.
Please state your name and address for the record, please.
My name's Corey Rhodes. I'm an attorney with D'Ambrosio Brown, LLP, 14 Proctor Avenue in Revere. Thank you, commissioners, for having this continued hearing. To briefly restate our position as fully described at the last hearing, my client, Mr. Moab Abu Galala, is the owner of Corner Taste and the lawful tenant at 1 Unity Avenue, and the owner of the business at this address. As we've submitted, the lease that was between the parties was signed in September 1st of 2009, expired in August 31st of 2014, as noted by the commission. The tenancy continued after this point. So the lease has expired, and now the parties have gone on under terms that would be called tenancy at will. That is month to month, people are paying rent to have space, and that is exactly what continued with these parties. My client entered into an operating agreement that was for what he viewed as the continued management of his business, not somebody else running a new business or taking his property and converting it to their own and opening up a completely new place with a new name. This is something that is being fully litigated in the Superior Court. Similarly, I'm actually not the attorney in the Superior Court case. I am handling the licensing matter, though. I would say that the 90% of these common victual applications are a pretty pro forma review of, do you have tenancy, do you have inspections, do you have the property to cook food. This is a little bit of a different matter, as you can see. And the Commission's authority here, their discretion here is broad, and really puts it on the Commission to look to whether this license shall be granted and whether, in their opinion, the public good requires it. And I think, given the numerous concerns that have been raised and regarding the validity of the applicant's business and whether their tenancy is valid or whether my client's tenancy is valid, there are serious questions raised about whether granting this license to this applicant is in the public good, especially considering, as I referenced last time, this applicant has already been operating at this property knowingly and somewhat blatantly without a license, going almost nearly a year without the proper license in place, though he knew he needed to have one. Beyond that, I think, though no one wants to see a restaurant get shut down, I think there are enough facts here that show that and give this a Commission authority to deny this license. And I think to some extent it would act as a catalyst in this case, getting these parties to get together and get this figured out. I'm happy to answer any questions you have.
Any questions?
Again, I go back and ask you the same question.
Sure.
So there was an operating agreement between your client and Diego, Mr. Diego, for 2 years, from August 1st to 2015 to July 1st,
Correct.
2017.
Correct.
And I mean, aside from lease, I mean, it could be a lemonade stand.
Yeah.
There was an operating agreement, and
And
that was broken.
Exactly, yeah. They entered into this 2-year agreement where the applicant was going to run my client's business at this location. And within 3 months of that, he stopped paying. The landlord stopped taking his rent checks. The landlord didn't notice him, didn't serve him with an eviction notice, didn't give him a notice to quit, anything like that. All my client's assets in this business suddenly were under the control of the applicant. And this is what predicated us to file a case in the Superior Court.
And who owns the property, the personal property now?
Our contention is my client. It's always been his property.
Spent over 150,000 here.
And, okay.
He even asked me for 3 years.
Please come up and state your name and address for the record, please.
Yes, my name is Mahawad Abu Galala. I live on 9 Pearl Ave, Revere, Massachusetts, 02151.
Thank you.
Yes.
So you've paid $150,000 for that.
I spent over 150,000 to get this business from the trash. I got money from here to there. I got a loan. My blood is everywhere in the business.
So
I got it. Yes.
I'm sorry. So when you say this is, I recognize this is a dispute over the ownership of the restaurant or the business itself, but is it your understanding that well, actually, this is probably a question for Councilor Cipolletta. Councilor Cipolletta, my question to you is, do you feel that the personal property, how do you view the personal property? Is it the ownership of Mr. Percato or is it Mr. Abu Galala?
There's a reference to, pizza reference or something, in the first lease, and I don't know that pizza reference was there or not, but my client as well has put a substantial amount of money into the improvement of the restaurant and its equipment. So our position is that the restaurant and the contents belong to him. I mean, no, I'm sorry, it doesn't. The personal property belongs to him. The restaurant, actually, the restaurant belongs to Mr. Previty. And I think Mr. Previty has some things in there as well.
Thank you.
Mr. Cipollette, so when I keep driving on this operating agreement, was there a reason why he killed the operating agreement? I mean, was it financial?
Previty told him he didn't have a lease. So we're calling it an operating agreement because at the top of the page it says operating agreement, and if we called it a lease, we'd confuse it with the other 3 leases. But if you really read it and try to read it in connection with what the prior owner's argument is, it's not an operating agreement. I think the prior owner is saying, I brought this guy in to run my business. Well, how is Diego paying to run somebody's business? It should be the other way around. It's a sublease. And the sublease was illegal, or if it were legal, it ended when the lease terminated at the end of September of 2014. And when Mr. Previty saw Diego and his family still in there, he said, what are you doing here? I don't have a lease with you. Nobody has a lease. Then he convinced him to sign a lease, and he did, and it's for 3 years with options. So that's why this all happened. Mr. Previty decided he was going to give the lease to Diego rather than renew the expired lease with the prior owner. And that's how Diego ended up there after that period of time.
Great, thank you.
Thank you.
Council Rhodes, so from my point of view, it looks like, whatever the number was, I mean, we know what the number was, but it looks like, for a 3-month period, it looked like he paid a rent plus operating agreement in some form or fashion. Did it go anywhere beyond 3 months?
No.
Okay.
No.
Anything else you'd like to add?
I guess I would just say that the fact of, however, the landlord and the applicant discussed how they were going to break these agreements, it was not proper legal advice. I don't think it was a proper legal understanding of what had to happen. If they believed that they could break them, I think there was notice that needed to be involved, especially given my client's tenancy there, as I laid out in my correspondence. You have to give a notice to quit. You have to take somebody to court. You have to evict them. These are things that have to happen to end a lease by law. And we're not just talking about a written document lease. You've probably seen many types of agreements where someone rents a piece of property and they've done nothing more than spoken or just interacted. It does not have to be in writing for a period of years.
Great, thank you. I mean, from my point of view, without getting into the merits of the court case, it just seems to me that I'm sympathetic to Mr. Abu-Galala. To me, it doesn't seem that somebody is going to turn over a restaurant for that type of payment. Having said that, I don't think the city of Revere should be in the middle of a court case. I'm not putting this in the form of a motion yet, but my opinion is that like I said, I'm sympathetic to Mr. Aguilala's position, but there is a lease agreement in place right now. Mr. Picado occupies the space. He has demonstrated that he can run a restaurant in spite of the debate between the parties on on whether he can or not. I just don't see how the city can make a decision based off of the information that's in court. I guess my recommendation would be that, you know, if Mr. Abu Galala was to prevail in court, then, you know, what I would do is reinstate the license at that point, and assuming that the license got the approval from Mr. Picardo today, that he would surrender the license at the conclusion of the case if it does, if Mr. Abu Galala does prevail in court. And then Mr. Picardo could go out and find another location and apply for a new license or a transfer of, probably a new license, I would think. But, I mean, that's how I see it right now, because what I don't want to do is I don't want to put the city of Revere in a position where we're trying to decide on the outcome of two businesses, both of which, you know, both parties have a lot invested. Like I said, I don't see anything that doesn't qualify Mr. Picardo from operating a business if he took this business and he went to another location. But again, I'm very sympathetic to your position. I just can't foresee a situation where we're making a decision based on the facts that we see today, and how who occupies the space, who has a lease, that kind of thing. Again, I think if the court's decision ends up differently, then I think I would approach it from that standpoint. But that's my point of view at this point. I'll let Commissioner LaCroix weigh in on that position.
So, if Mr. Presadio, if he was the only party here, then I think, pretty much an easy decision on my side. My problem is he has been running an operation without a license. Now, I understand he did come here. I mean, forget about the lease stuff. I understand that's in court. If there was no lease issues, he's still running an operation without, I don't know, knowingly or unknowingly, I'm not sure. I don't know how, he did make some efforts to get the license in play. I don't know if it was the commission's, issue that it wasn't, pushed through sooner. So he did operate a full year without a license, which to me, shame on us for not getting on that.
I think it was a position that we took whereby there was a dispute between the parties, and the city did not want to be involved in that dispute. And so what we did was, at that point, it was in the middle of the year when that dispute took place, and we were hoping that it would resolve itself before it came up for renewal. Having said that, the dispute remains, and given the situation that we're at today, my feeling is that we've got to go with the facts that we have today. And to me, the facts are that there is a lease agreement. Mr. Picardo does have control of the property, and that ultimately the decision will be left with the courts. And once the courts decide, I think that we could take a position after that's been resolved. But until that time, I just don't want to put the city in a position where we're making a decision, based in a vacuum and not having all the facts, because you could weigh in on one side and find out that at the end of the court process that it went the other way. And my feeling is there isn't anything that prevents Mr. Picardo from going to establishment and open it up. He's in possession of this, and I think, based off that, you have to sort of review his experience in that, and his experience tells me that, he has the experience. I don't necessarily have to agree with, the position on the court case, but that doesn't really weigh in here. The facts weigh in. The facts tell me that you had the landlord come up. He's telling you there's a lease. Mr. Picardo told you there's a lease, and he's applying for a license, and that's how I see it.
That's true, but the fact still remains, we did operate for a long period of time without a license, so I almost can equate that to driving a car without a license for a year. You just didn't get caught. Again, this isn't to do, not 100% fault of your own. So does that put someone in good standing when they go for a new license, if we want to, at least all lease stuff aside? So that's where I'm having this dilemma here, because there's the two parties, someone's going to get hurt. I don't want to hurt anyone. And he's been operating a good establishment, from my understanding.
Well, I think we're both in agreement there, but again, I don't think it's the city's position to be making a decision on something that is ultimately going to be resolved in court, and that's where I fall back on. If the roles were reversed and Mr. Abu-Galala was in possession of the property and he was operating, I would find that way, because I just feel like those are the things that you have certainty on right now. You don't have certainty on all the other things until they're resolved in court.
If I may,
Sure,
one statement.
absolutely.
I guess to get to that point, you're saying they are checking off all the boxes, that they have a lease and things like that, but I would argue that we have just as much right to be in the property, but this is America. You can't go in, you can't self-help, you can't kick people out physically. If there's this debate about who has this legal, what leases or what rights may be in this property, even just with the two agreements that are before you, I'm wondering if it would be helpful if there was some opinion from the solicitor's office, potentially to guide the commission as to their interpretation of the documents and the law at play, if that might be something that would, for once and for all, give you some determination of if they are actually checking all those boxes, because I'd say they're not.
I mean, I don't think it's the city's position, and I can't speak for the city solicitor, but I don't think, common sense tells me that you don't want to get involved in the middle of a court case. We're not privy to all the issues associated on both sides with the court case, and so I think it would be difficult for any person to be able to make that decision. And that's why I kind of fall back on the fact that I can only deal with what I know at the moment. I don't necessarily have to agree with my position. If you're from a personal standpoint, but from this position, those are the only things that I can put my hat, hang my hat on. And
it does sound like, to some extent, though, those are not necessarily concrete feelings one way or another. One party is necessarily right versus another. So it sounds like the decision is basically to hold the application in abeyance, depending on the court case. Because you can't actually check those boxes off for my client or their client. So I'm not sure how the commission can rule either way.
Well, I can rule on the fact that I have a new application and a lease from the landlord, and he now has all inspectional services signed off on. My understanding is that the last food permit was taken care of, I guess, over this past week. So from my standpoint, I've got an applicant here who has all the approvals, and I've got a landlord that has a lease, and I've got an applicant who's applying for a common victuals license. I mean, those are facts right now, as far as I can see. And like I said to you, I can waver on personally how I feel, but you know, we're in a position right now that I don't see a way that, you know, we can turn down a new applicant based off of those facts. And that's how I see it. You know, my colleague may think differently on that. And having said that, when it does come to a vote on a motion, I think if we're in opposite sides of that, then we're going to have to table this until Commissioner Bucanasso has an opportunity to weigh in, which we'll touch base with her this afternoon.
So just to put sort of a finer point on what the chairman had.
I haven't put this in the form of a.
No, I understand that.
Okay.
Oh, okay. Yeah, I wouldn't speak on it if you had already moved it.
I just want to be clear on that.
If there were some ambiguity, I would say there's some value to sending it out for a legal opinion, but there's no ambiguity. The leases that you have before you is one expired lease and one new lease that's in,
But I don't
that's
think it's our
active.
position, counsel, to
No, I understand.
you know, weigh in on the merits.
No,
of-
that's right, and I was speaking to the point that there might be some value on getting a legal opinion, but only if there were ambiguity, and I don't see ambiguity here. So to the extent that Diego's been closed, he's already lost 1 week's worth of food, at least a weekend's worth of food at the place, that's been locked up. I'm not sure over the course of the time whether or not there was, he was under the impression for some period of time that he was working under the prior owner's license, because that was sort of the way it was written when that operating agreement was signed. And at the time that the license, the lease expired, then he entered into a new one and came to the city and said, it's me now. It should be in my name.
On that point, so it is your client's understanding that he was operating under Mr. Abogala's license?
At the time that the license was active.
Active, correct.
Right. The operating agreement, so-called, which is a sublease, speaks to the operation of the establishment under the then current license. Then the license expired, and almost concurrently, the lease expired. So they had, because the license goes to the end of the year, the lease actually expired, whenever it expired, I think September, October, whatever it was. But then with...
Then the court issue became...
Then the court issue came up, and then the commission...
So he kept operating, he kept operating, assuming, I guess there's some assumptions here that the license would just...
Would issue at some point.
Would issue at some point.
And during all that time, he actually had the inspection. The inspectors know him well. So, anyway, that's...
No, I understand.
Yeah,
I
and we
get
don't...
it. I get all that.
We don't...
About the first time, just he gave him the license through me, because you know I'm the owner.
Correct.
I've been there 16 years. He has nothing to do with that. He gave it him because me. He's no because now.
So we don't...
He never worked for me.
We don't have any difficulty
He knows something.
in surrendering the property, obviously, if Diego is not successful in the Superior Court. He'll just take the license, or take his business and go somewhere else, because if that's what the court decision is. So if he loses in court and possession is given back to the prior owner, then obviously would surrender the license. I mean, that just makes sense.
Any questions? I mean,
No.
I mean, that's what I fall back on. Like I said to you, I think that if this was, in spite of the dispute on the business, if this was at another location and you were applying for a license, based off the ability to run it, to demonstrate that you have the ability to run it, I just think that I just can't. My feeling, or my the things that I fall back on are the facts and of what I know right now. Go ahead, Counsel.
I guess, I mean, we do talk about the lease and we talk about the facts. We had this tenancy at will in place, going for 14 months after our written years-long lease expired. But you really still need to show some sort of abandonment or leaving the property or something like that. To the other side, we had this operating agreement. We're specifically showing that we were going to continue on at this property.
I agree, but that's where the dispute comes into play, and my position on that is you're going to debate that in court, and however it prevails, we're willing to make the necessary changes to do that. Like I said to you, I think that well, you know what my position is. I haven't made it in a form of a motion yet, but if it were to approve, I would make sure that Mr. Abou-Galala has the opportunity to, if he were to prevail in court, to get his license back and to operate, and that we would revoke the license of Mr. Picard.
I guess my only other piece on just whether he's fitting the requirements for the licenses, the actual facilities to produce the food. I mean, if it could be demonstrated that he has a bill of sale for the things that he's purchased, does he actually have the resources, the equipment in his ownership to make this food? And we'd say that that's all my clients' resources that have been ill-begotten.
I mean, from my standpoint, we don't normally go into those depths of ownership on how they operate their businesses. He's in there now. He's operating. He's got a lease, and he's applied for a license. I mean, that's all I can go on today.
I guess just my final point, if in a traditional circumstance, if this was one business taking over a location transfer or something like that, there would actually be a common victualler transfer application. They would be transferring from one business to another. I think there's still substantial questions as to how this all happened, how this all transpired, why it wasn't being transferred from my client, who was, I'd still say, the holder of this license that is not renewed.
I don't disagree on your points there, but like I said, I still fall back on that he's coming in as a new applicant. Regardless of whether you think it's right, wrong, or indifferent, he's coming in with a new license, and he's demonstrated through the licensing, through the inspectional services, that he's passed all of those, and he's got a lease, and that's all I can weigh in on at the moment. So, I mean, that's all I can tell you at this point.
Thank you, sir.
Thank you. Any other things that you'd like to add before? Thank you.
That was just for informational purposes.
Council, it's pretty clear to me that we're not going to come to a decision, and there isn't a tie-breaking vote. As much as I'd like to get this resolved today, and this, can serve, for both parties, is that we want Commissioner Guanasso to weigh in on this issue. And so we're bound by making this a public meeting, and we've got to give 48 hours notice, and we're going to have to extend this to the 48 hours and reconvene on Wednesday. Is that the 48?
No, because now it's Monday at
Yeah,
4 o'clock.
Monday, 4 o'clock. So it'd be Thursday, unfortunately. What's that?
I'm on vacation as of Thursday until after closed.
We're going to have to just get somebody to
Yeah.
fill in for you.
It's
Yeah, we'll make arrangements. Unfortunately, that's the position we're in at the moment. I think that, I just don't think we'd come to a decision, and if we came to a decision, it would be binding, and it wouldn't give Commissioner Guanasso an opportunity to weigh in. Council?
So the difficulty I have with that is that we adjourned it to today, and we, again, had another lengthy debate and presentation again today. And one more day, he's closed. And if, I don't know what would happen or would be different from today on
Well, the
Wednesday or
problem is-
Thursday.
the problem
But
is,
what I
Council,
do know is that he's not open and he doesn't have any right to appeal yet. So I'm concerned about two things. One, that he's losing money every day that he's not open. And the other is he can't go get an injunction to open unless I force it and somehow force a denial, which doesn't appear to be the intention of the commission. And we really don't want to go down that road, but I think it's really unfair to Diego to be closed, and it's not his fault. None of this is his fault, and the fact that
Well, none
the
of that
decision...
is our fault either. I mean, you've got a dispute between the parties.
Well, I understand that,
We're trying to
but
resolve that.
I get it.
I mean, that vote can just as easily go the other way.
It can go the other way and would be in court, would have an injunction, would have been open by
That
now,
would
and
be
I
fine.
guarantee you that. But what I'm
And that would
saying
be
is,
perfectly acceptable.
well, you know what, that's, we
I
came
mean,
back here.
that's your right, Counselor.
Yeah, it is, but you're taking it away. And what you've done is you've closed him. And we agreed to come back here on the premise and the understanding that we would have some sort of a decision. And now we've had a second hearing, and we still don't have a decision, and he's not open. I would ask, at least, did you allow him to stay open pending the commission's final decision as to whether or not you're going to give him a license? Because let's say you give him a license, whether it's Wednesday or Thursday or next Monday or whatever, how do you repay him for the time that he's been closed? You don't. So, well, his client doesn't have a license or an application pending. We're coming up on October, and he still doesn't have an application before the board. I don't see where this is so difficult.
Counselor, technically, he doesn't have a license either.
We have an application.
You have an application, but that doesn't
The
mean
other-
it gives you the ability to operate without the approval of the license. Is
No,
that
but
correct?
it gives us the right to expect that somebody's going to act on it. My point is, in response to my colleague's position, is that at least we have an application pending.
You do?
The prior guy does not. So, I mean, you're acting on his and on Diego and whether Diego should be granted the license. There is not an application by the prior owner before you to act on, so it's not an either or. If Diego doesn't get it, it doesn't mean that the prior owner gets it because...
No, that's correct.
Right, because
That's
there's
absolutely
nothing
correct.
there. So, I think...
What's your point?
Well, my point was in response to the attorney's comment
But I'm
that,
not,
well,
I'm
he
not
doesn't...
commenting on the other,
No, but I was
side.
replying to it.
okay. But I'm not I'm
And I know where you're going, and I agree with your logic,
right.
so I'm not I'm not arguing with your logic or the route that you're going down. And it makes sense. I'm asking the commission to grant him a provisional license until the court decides which one of these gentlemen is going to have possession of the store on Unity Ave. I think that makes all the sense in the world. Nobody gets hurt. If the store is empty, the prior owner's not in there. If Diego's in there, the prior owner still isn't in there. But at least Diego, who's been operating, is continuing to operate under his lease. And I think he deserves the license. I see no reason to not give it to him. He hasn't done anything to offend the city. He hasn't gotten any violations. I mean, it just makes an enormous amount of sense. And if we're willing to stipulate that it's a provisional license pending the outcome of the court decision, I don't see how anybody gets hurt, least of all the city.
That's not the issue here. The issue here is I'm not quite sure that you're going to have the votes until it goes up, and if it ends up 1-1, we're going to need Commissioner Guanasso to weigh in.
I understand that, but I haven't heard a motion.
Well, I mean, what I'm trying to do is come to some type of resolution that would be acceptable, but at the same time, I'm sitting here with 2 votes, and you know, I don't know how that's going to play out, but based off of the conversation and the places that both commissioners are coming from at the moment, common sense tells me that we're not in agreement.
So you're anticipating that you won't get a second to a motion?
I am, but that doesn't
I
mean it would go that way.
wasn't party to what was going on, I'm sorry,
Yeah,
during your
well,
deliberation.
And that's the dilemma I have at the moment, is that based off our discussions, I don't foresee it going one way or the other.
And by the way, I'm not trying to convince you, I'm trying to convince
I know
the
that,
other
I know that.
commissioner. But I need to speak through you, so I mean, it just,
He's been operating for the last year or so, I guess. You know, maybe I'd be inclined to you know, make a motion that, you know, he has the ability, now that he has all the permits, to open up until we can get this resolved with Commissioner Guanasso at the.
Yeah. So, you know, circumstances happen, right? Circumstances, Commissioner Guanasso was supposed to be here.
and
Very
sometimes
important.
creative solutions
Yeah.
can win the day.
We were supposed to have him, he was supposed to have his paperwork. I think in January, he didn't return his paperwork, is that correct? So he was supposed to do it, he just didn't do it for whatever reason. I feel more comfortable when I make my final decision when there's 3 of us here, and we had no idea she wasn't coming, no idea. I haven't decided, I don't want to make a vote without her here and hurt either party. That's where I'm coming from. So that being said, I have no problem for him giving a provisional license until we reconvene with Commissioner Guanasso. And that could be Thursday or next week, as soon as we can. So the 3 of us get together, then we'll come with a final decision if everyone's agreed to that. I'm okay with that, Joe.
Just a few
So
comments.
this would be a vote to give Mr. Picardo the opportunity to run the business while he gives us enough time to post it in the paper and call for another special meeting for it.
I guess just a couple of points on the converse of that. First, this hearing was going to be scheduled for Wednesday, so in reality, we're only talking one more day than was already originally
It would
agreed.
actually be Thursday, right?
Well, it was, I mean, from last week, we were scheduled to meet on Wednesday. This is really only one more additional day from what was previously agreed. For the council to talk about parties being hurt, my client's had lost income. He's had his lost business for now over a year. So a couple of days, especially where the applicant has been operating, has been making income, running his business there for well over a year without a license, it doesn't seem like it's too much of a stretch if he goes another few days. And it seems strange that if we're just going to go down some provisional route and it just get overturned in the end, it seems to be a kind of a legal gray area or
It may,
somewhat of a
but,
strange area.
you know, here's the reality of it is that we don't know what the outcome is going to be in court. And so either way, siding one way or another, I mean, somebody's going to get hurt in this transaction. And what we're trying to do is, we're trying to provide a solution to all parties. We're sympathetic to Mr. Abu-Galala. You know, like I said to you, the facts push me to one side of this. That doesn't necessarily mean I disagree with him. However, having said that, he's been operating, you know, if he's got an investment in the business as well. And right now, you know, we closed him down. If my feeling is we don't have enough facts to you know, to close them down. We're making a decision on a new application, and my feeling is that, you know, I'd be inclined to give them a provisional license for a couple of days until we have the opportunity for Commissioner Guanasso to come in, and then she can weigh in, and then we can put it up to a motion. I don't think that's unreasonable, given the facts that we know.
I guess just to the extent we don't know how it's going to happen in court. We don't know how it's going to go on Thursday.
I don't, but I mean...
We're
that's
on
right.
again,
It
off
could go-
again.
I understand. It's unfortunate. It's unfortunate. I mean,
Yeah,
I'm
yeah.
sure it's
No,
something
I'm
out
not
of
blaming the
everyone's
commission.
control.
I didn't mean to.
But having said
suggest
that,
that.
you know, it's, you know, we want to believe me, we want to resolve this as quick as possible.
Yeah.
You know, I can tell you one thing with certainty: we're going to have this thing resolved a lot sooner than the courts will.
Correct.
So,
That may be true.
with that, unless you, unless you have any other
I guess
objections.
it's, you know, it's just, I go back to that point, and I don't mean to beat on it so much, that he has been open. A few more days is really not critical in comparison to, what are we in, the end of September now? He's been operating without a license. You know, he should have been potentially not operating that entire time. So a few more days is not going to break everything, and then we'll have a consistent and clear record if this is going to go up on appeal.
Great, thank you. What, so do you want to make a motion?
So I'm going to make a motion to allow a provisional license until we reconvene as soon as Thursday. Thursday, the 28th.
I think we should check with Commissioner Guanasso first.
No, I understand. So how do we make a motion if I have to check with her first?
Let's make a motion on that. We're going to give a provisional license until we have an opportunity to confirm with Commissioner Guanasso on a date to be held within a week. So by next Thursday?
Yeah, or sooner.
Yeah, well, that's my point.
Yeah.
You know, and then we'll make sure that both councils are available.
Yeah. So I'll make a motion to allow provisional operating license to Mr. Preciado from now until within 7 business days within 7 days of today.
Right, and I'll second that motion. All in favor, say
Aye.
aye. Aye. Thank you, guys, appreciate your effort, your input. I'll make a motion to close the meeting. Is there a second to that?
I'll second the motion.
All in favor, say aye.
Aye.
Aye.